which happens to be Nilanjana Das, ZBA 23-00009, 130 Drake Road, Somerset, Block 376, Lot 21 in the R20 zone. It's an application to legitimize some construction that was done without a permit. I understand there's an attorney representing. Come on up, either table's more comfortable. We'll have to check out the mic.
And you need to use the mic.
May it please the board members, my name is Pete Laub with offices in Branchburg, and I'm here representing the owner, Nila Das, seated behind me. This involves an application for property located at 130 Drake Road, more formally known as Lot 21, Block 376. It's a single-family residential home. It is zoned in R20 residential zone. By way of history, the owners had hired what they thought was a reputable contractor, Eden Construction from New Brunswick, to install a addition to the back of their home. At the time of the addition, there was a pre-existing concrete slab that covered that portion. Eden Construction constructed the addition. That was back in 2018. Then in 2021, the owners had made an application for refinance, for which an appraisal was required. In the course of that refinance and appraisal, the town building inspector was contacted by the appraiser, and the town came out and notified the owners that they required permits. At that point, it wasn't known whether variances would be required or not, but they were told they needed to apply for permits. They attempted to, or did, file an application for permits. Were told that that application was denied because they needed variances. So we're here tonight before this honorable board seeking approval for what we describe as after-the-fact construction of the addition to the back of their property. It's about 700 and a little bit over 700 square feet to the rear of the home. That construction involves a request for variances for side setback, as well as total side setback, and most significantly, based on the comments that we received, is impervious coverage. With regards to the side setbacks, as it's explained in the application, 11.25 feet is presently constituted on the property when 15 feet is the required based on the zone. The total side setback required is 30 feet. The property presently has 23.02 feet. With regards to impervious coverage, as the zone requires 25% as a maximum for impervious coverage, this particular lot now constitutes impervious coverage at 23.02 feet. We have reviewed, and I've discussed with my clients, the comments from the technical review letter dated April 18, 2023, as well as the report of Tara Kenyon dated April 25, 23. We've consulted with our civil engineer on whose plans we're relying upon, submitted with the application, and his name being Steve Parker, local civil engineer. And we discussed the comments with him. He has recommended, and my clients would agree, as a condition, should this board approve of the application, my clients would agree as a condition to submit site drywall plans to the township engineer for the township engineer's review, and any resolution approval of this application, the owners would consent would be made subject to, conditioned upon the approval of the township engineer for a drywall on the property. As stated in our application, we feel that the granting of this application and the variances would outweigh any detriments to the public good. We do believe that the addition as presently constructed is a benefit to the neighborhood, increasing in values. My clients are not aware of any complaints. As mentioned, this addition improvement has been on the property for 5 years. I don't believe there's any of the neighbors within the 200 feet are here tonight.
They're coming later.
Okay. Well, let's hope it's after the board is gone, I guess. But we did supply the certified notice to the residents within 200 feet. We've supplied the proof of that notice to the board, and respectfully request that the owner applicant did not in any way purposefully, knowingly disregard any of the building requirements, zoning laws. They relied on what they believe to be a reputable contractor, and are here today requesting the board's approval of what we describe as after the fact construction.
Have they sued the contractor? Have they sued the contractor?
There wouldn't. At this point, there's really, if this board should deny this application, then that would be an issue that my clients would have to consider. But no, as it presently stands, talking to you as a lawyer, there's no known damages that my clients sustained. And even if the plans were submitted prior to construction, the board may very well have requested some sort of dry well because of the impervious coverage anyway. So the fact that my clients, as a condition for any approval, would consider the installation drywall would probably have been part of the approval if it was before construction application.
How long have your clients lived there?
The construction was in 2018. They're here if the board would prefer to talk to them directly.
I would.
Neela Das is the technical owner of the property. Her husband is here, Shiv Kaur, who may be more familiar with the actual details of the construction, the history. But Ms. Das is here as the owner of the property, and her husband, Shiv Kaur, is here perhaps to answer any more technical questions.
Can I swear her in?
Please.
Could you grab a microphone, please?
Sure.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yeah, I'll tell the truth, the whole truth.
Okay. Please state your name for the record
Yeah, my full name is Nilanjana Das,
and your address.
130 Drake Road, Somerset, New Jersey, 08873.
Thank you.
Okay, ma'am.
You all can have a
How long
seat.
have you lived there?
We had bought this property in December 2013, and still now we own this property and live there.
Okay, now, what was there in the backyard when you moved in?
It was a concrete patio all over, till up to the pool. It was concrete patio.
The pool was already there,
Yeah,
and the sheds.
yeah.
And did you add anything other than the extension on the slab?
No. The slab was there when we had bought this property in 2013, covering the entire area.
And the pool was there when you bought the property?
Yeah, it was
And
there.
the shed was there when you bought the
Yes,
property?
it was there, everything.
Okay. I went there today. I knocked on the door at one point. Nobody was there. I saw there's at least one disabled car in the driveway, and grass was about foot high. I'm surprised you're living there, actually.
Yeah, we had just sprinkled some grass seeds and are allowing them to grow to the full height before we mow the lawn completely. And the car that you saw, it's his car, by the way. I mean, he is holding it and yet to sell it off, so it's ours.
Okay, all right. Now I have a question for our zoning officer. Does the shed contribute to the building coverage and also impervious coverage?
Yeah, a shed will count as both.
Okay, all right. That's all the questions that I have.
Okay, I've got a couple. The contractor, now, he said he was going to get permits.
Well, it's my understanding that that never came up in any conversation. My clients here did testify, but they just hired the contractor to do the job. They had no knowledge or information about the necessity of permits or approvals, and they were not aware of that requirement until as I mentioned, they were applying for refinance. There was an appraisal. The appraiser apparently got in touch with the town, and someone from the town had said they need to apply for permits. They made that application. It was denied because of the requirement
Gotcha.
for variances.
We'd really like to hear that from your client.
Yeah, absolutely.
Okay.
Maybe Mr. Carr would be the better one to answer those technical questions.
Okay, I'm just going to swear you in before. Can you please raise your right hand? Do you swear to tell the truth, the whole truth, and nothing but the truth?
I do.
Okay, please state your name and address for the record.
Chief Carr, 130 Drake Road, Somerset, NJ08873. So we contracted this company.
Mr. Carr, just give the board a little benefit of your background. What do you do for a living? So a little bit of familiarity with you.
I work in IT. I'm the director of IT of a company in the West Coast, Funko. And we don't know much about construction. First time we are building addition here. So somebody recommended us this company, Eden Construction, based out of New Brunswick. And they do a lot of construction activities in the New Brunswick area. And they came and they gave us a breakdown of the options we have for extension and the price breakout. So it never came across our mind for the permits. So we thought that whatever needed, they are going to take care of everything. And that's the way it went. So one thought was that they asked us, so we wanted to get a loan, a 203 loan or something that time to build the extension. And they said that it's going to take a longer time, and very tough process. Said, first do the construction, then you can get the loan, refinance it. So that's why we did the construction first, and then we were applying for the refinancing.
Explain to the board how the information came to you about the necessity for permits. What happened?
I guess once the appraisal was done on the property, then it triggered in the township records, I guess, of the changes in the property structure. And that's when we got a letter from the township on the permits. So we first called Eden Construction about the permits, So they came us, first time they came, and then when they asked for the permits, and they would not take our calls anymore. So we had to engage a different contractor to get the permits and regularize all the work. And so they did all the permits and then submitted the permit to the township for the approval. And then that's when the township officials, they asked us to go for a variance on the impervious coverage.
So I have a question about the permits. So you're saying after it was built, I'm still not following, when did you apply for the permits?
We applied in 2021.
But I mean the sequence, so this was after it was built and you
After
were
it was built.
trying to get a loan?
Right.
That's what triggered And the township said you needed to get permits?
Correct.
And when you applied for the permits, you're saying that's when it was denied because of the variance?
That's right.
So during construction, now this is just a living room, right? Is that, the addition is just a living room?
Living
There's
room,
no
right.
plumbing or anything else in there?
No plumbing.
Okay, during the construction, were there any, did the contractor say anything about permits or anything about inspections that had to be done when he finished electrical or anything like that?
No.
Nothing. Okay, Mark, I have a question for you.
Sure.
Now, this has happened before. Can't the contractor be liable for this? How would we get rules or regulations or whatever, making it so that the contractor has to have some liability?
It's a good question that I can't really answer.
Where does it say that the owner is totally responsible and not the contractor?
So, sorry, if I could just jump in. Like, when you
I'm
say.
hesitating because I'm
Yeah.
not sure that's really a question I can answer.
So, when you say liable, now, I think that gets back to Mr. Laub, to his comment about there being damages to the applicant here. For example, if his application was denied, then the applicant would have damages, and the contractor may be held liable for that. Now, in terms of like his business practices, like, I mean, there's different consumer bureaus, business bureaus in New Jersey that, should the applicant want to, not giving you legal advice, but those are options you could pursue. When you say liable, now, if you were asking about like what the process is in the town, for there to be like inspections of these different places to make sure, oh, I see construction, I don't know what the town of Franklin does with the buildings department. I don't know, Mark, if you can
Yeah,
speak to that, but.
I think what may have happened process-wise, and I do remember getting the zoning permit, I believe, I mean, well, they described that, I guess in the process of getting refinanced, the appraiser, it's not uncommon for them to find out about the status of permits for the property. Sounded like they went to the building department. When somebody does something without getting permits ahead of time, well, the one way to cure that is to then go and get people. It happens a lot. People will finish their basement, and then they go to sell their house, and the buyer's attorney says, well, show us the permits for the basement. And the seller goes, oops. So then they have to go get the permits for the basement that they've already finished. And the way to cure that, again, is to go get those permits. I think what happened here is that, I think that's what happened. They were told to, oh, you did work without permits? Well, submit permits. The first step in that process is to go through the zoning department, because we review it to make sure that it complies with the zoning ordinance. And in reviewing that, I probably reviewed it, saw that they needed setback variances and impervious, and the variances that have been stated. So then, well, how do you cure that? Well, you go to the zoning board and you ask for the variances that occurred. So I think that, overall, I think that's the process that has happened since now. And did I say anything that doesn't, that you would not agree with?
You're correct.
Okay.
I have a question, clarification. So if the house already had the concrete pad and also the shed, which apparently was also not within, so was it not okay when it was purchased already?
I think there may have been some pre-existing, I don't know if the concrete pad was the full extent of the addition.
Was it?
We'll get to that, but certain things like the building, I think they have a building coverage variance, so the patio would not have counted towards building coverage, they added the addition, so that was a new variance. They also have total side setback and side, so that they added new building, and setbacks don't apply to to patios that are on the ground. So to the extent that they added more buildings, so they created a need for a new side yard setback, a total side yard setback, a building coverage. So there's at least 3 more variances that were created by doing that addition. Whether they were already over the impervious, that the site, I should say, was over the impervious, I suspect they were. Whether this made it worse or not, I don't know. The shed, we've heard that the shed was already there. The shed's kind of an afterthought, the shed's there, so usually when something like that, it's identifying an existing condition. And I don't think the shed was the issue here, creating this whole, they're not here because of the shed.
Mr. Carr, can you respond to your question about the relationship
how
between the
often
patio
were-
and the addition? If you would explain to the board the relationship between the addition that was put on and the foundation that was pre-existing.
Yeah, when we bought the house, it had a patio which went off to the pool, and that thing was covered with a patio. And there was a shed in there already. The pool was there, and it was a nice water runoff. It was properly landscaped to take care of the water, drainage and everything. So we made it a covered patio, I would say. So the patio had a roof now.
In other words, the addition that was built, you used the pre-existing patio as the footing, the
That's correct.
foundation.
I guess how much of the impervious coverage was already over and how much additional added by the construction?
That's probably more of a question for Mr. Healy, but technically, it was the same amount, just the water was directed differently. Instead of having a flat patio, you now had a roof structure directing the water.
So are you saying the addition is simply putting a roof over the slab, or?
Yes.
Practically, that's what happened.
Yes.
They technically, and he could explain in more detail if you needed, they technically used the patio that was there as the footing to build the addition.
Right.
But the addition is not just a roof. The addition is, they enclose the whole thing to make it a living room.
Wait, does that change the impervious?
No, it doesn't change the impervious coverage, no.
So in terms of whatever violation to the code, it sounds like it was there when they purchased the house?
And if I may, what's being proposed with the installation of dry wells will improve this lot, even though the impervious coverage may have pre-existed anyway. So by putting the dry wells on the property will be an improvement and may have been required if the application was filed and made before the construction. The board may have said, based on comments, we need you to improve the impervious coverage, and at that time, dry wells may have been a proposal or as a condition for the approval, which is what we're submitting to the board tonight, is that we would consent to a condition of any approval that it's subject to the installation of satisfactory dry wells. When I say satisfactory, I mean in accordance with the township engineer's approval.
And so when we have a program where we can look at old aerial photographs. It looks to me like the addition is slightly bigger than that patio. What I have here is, the addition goes basically the full width of where the house is 2 stories in height, whereas the patio was maybe 80% of that length. And then at least it looks like here, like the patio didn't go all the way to the concrete surrounding the pool. Whereas when you look on the plans, the rear of the addition touches the concrete. So that looks, maybe it goes out maybe 3 feet more than the concrete patio. That's looking at an older aerial photograph from Google. So it's probably roughly 80%, I would say. So it's maybe 20% bigger.
This gets to another series of questions that I have. What do you use the shed for?
For storing lawnmower and stuff.
Okay. Because when I look at this, I think that a better solution would simply be to remove the shed, to get rid of the shed. I think that would reduce both the building coverage and the impervious coverage. But I don't know how you'd feel about that.
It also eliminates 2 variances.
Yeah,
Okay.
Does that impact the setback? The shed? Does that impact the setback? Is that the variance you were
no,
referring to?
but there's variances that relate to where the shed is placed.
I think there's a rear yard and a side yard.
It would seem to me that that would be the way to,
The shed's what, about 8 by 10?
Yeah, I would think so, yeah.
It does reduce the impervious coverage a little bit, not tremendously.
no.
I think if this is approved, I think there's probably definitely a need for the dry well.
Yeah.
Any other questions? I'd like you, though, maybe to give us a little more of a statement to justify the variances that'll be there. I read what you wrote, and what my interpretation is, there's really only one person benefiting by this, and that's the owner. I don't see how the variances that you're talking about here are benefiting anyone else in the neighborhood. What I did see, echoing Mr. Shepherd when I visited there, I do think that one thing that will address or help the value of the neighborhood is absolutely cutting the grass. He was kind, saying a foot high. I would put it at about 1.5 to 2 feet. And
Mr. Chairman, my client does have an explanation for that. They purposefully, and he could...
Well, she already gave the explanation.
Right.
But to us, it doesn't seem like a good explanation.
They did recede.
Right? Nobody lets it go to 18 inches or 2 feet. And you know that yourself.
what can you tell us to justify this? Something that, I know you're not a planner, but something from a planning point of view, so that we can't just say, okay, I think it benefits the neighborhood. I'm not, like I said, I'm not convinced what he's going to do benefits the neighborhood. It benefits him, and I understand that.
Well, as Mr. Chairman, you're probably aware, it's a balancing effect, essentially, under C2 variances and the approvals. First, we look at, is there going to be a negative impact? And honestly, this has existed for 5 years, and I noticed that there has been no complaints from any neighbors. Using the negative impact as a criteria, I believe the C2 variances can be awarded without creating any negative impact on the neighborhood. And likewise, I believe it could be approved subject to the conditions that we spoke about with the dry well without any substantial detriment to the neighborhood or the public good. And it doesn't negatively impact the intent or the purpose of the zone plan. The impervious coverage seems to be the primary issue, and based on the comments that were submitted from the technical review and the report of Ms. Kenyon, we believe that that can be adequately addressed by the way, by dry wells on the property, which is not an insubstantial cost factor, but it seems to be the best method to deal with the impervious coverage.
Okay. Other questions? Any?
I have a question. Was there ever an Oprah request or anything sent to the town? Like, were there any other resolutions or anything in regards to this property?
I cannot personally speak for the circumstances under which he purchased the property, but he could respond to that. Do you know what an Oprah request is, Mr. Khan? I can't speak to that issue. I didn't represent him at that time. You are certainly aware of the fact that that is a common method for attorneys representing purchasers to direct them to make an Oprah request to see if there are any open permits, and if there is permits, whether approvals are still open and pending. I don't believe that was done in this case, but I can't speak to that. I might mention, even if that was done in this instance, it wouldn't have shown any application for the permit for the construction.
Is your client, or did you make your client aware that there would be no room for any other structure on the property? Front yard, backyard, side yard, anywhere?
Mr. Chairman, I think based on the comments that he has heard here, I think he has been enlightened about impervious coverage and what you can and can't do. I think even if he considered any additional improvements on the property, I think he would know that it would require some sort of approval by the board, and so I think he's been educated.
I mean, we're not to have to beat a dead horse, but even expanding the tool shed, you know, it is what it is. It's what, if it's approved, it's.
Mr. Carr, you understand, should this board graciously approve of your application, even subject to the conditions, you understand that you are prohibited from making any other structural improvements to this property that could affect the impervious coverage? You understand that?
Yes, sir, I do.
Anybody else? Open to the public, and let us comment that there is no public, so we'll close. Anything you want to add before we?
I don't believe so, Mr. Chairman. We appreciate the time and attention. We do believe that the granting of the C2 variances in this case can be done in accordance with the necessary requirements imposed under the law. And again, we would certainly accept a condition of approval being subject to the dry well.
Okay, anything from the board? In this case, as a condition, dry well design and installation, does that also imply an inspection from the township?
I'm sorry, what's the question?
Is there going to be a final inspection from the township in terms of the dry well? And when it's considered that he's met the conditions, let's say, of a possible approval, is there going to be a township inspection?
Yeah, there'll be, so they, technically, I don't think the applicant, or the application hasn't moved through the construction department for the permits. If the board approves it, then they can move forward with the construction prior to, so they technically don't have a CO for that living room. Before they, we have a process in place where prior to issuance of that CO, the engineering department will inspect the site work, which will include the dry well.
That will be followed in this case, and that was the other question.
Yes, it's part of the process.
Asked before, does the new addition, was it inspected and does it meet code?
I can't answer that. I mean, the normal part of our process is, and I think it happened here, again, the cure, as I was explaining before, that, they were told they have to submit permits. They submitted permits. That process starts with zoning, and we basically failed it because it needed variances. And their permit review stopped at that point. So now after, again, if the board is inclined to approve it, then they'll move forward with the construction process, or construction permit review process.
Okay, would your client understand then that as far as the room addition goes, there, just so we're all out on the table, there could be something he has to add, change, or subtract for meeting code for that?
Absolutely, Mr. Chairman, and I will ask him that question, but I believe Mr. Healy properly accounted for the procedure. Issuing the permit is step one. Then the town building inspector will come out to make sure that the construction is in accordance with town codes. If not, Mr. Carr understands that he would have to bring it in compliance from a building code point of view. You understand that, right, Mr. Carr?
Yes, sir.
Another thing, a good rule for him to remember is if you want to do anything, check with the town for what you need or you don't need.
Mr. Chairman, I think he has learned his lesson about that.
Anybody want to offer a motion?
Okay, there you go.
I move that we grant Nilanja Das a variance to allow for the continued existence of the unpermitted construction of the living room on the premises located at 130 Drake Road in Franklin, subject to the need for the applicant to apply for and install a dry well to allow for the discharge of stormwater that would otherwise be unnecessary, except for the overage of the impervious coverage and building coverage.
Any second?
Thank you so much.
You want to add anything? Second?
I'll second.
Carol Bethia?
I'm going to say yes. I'd just like to voice concern about setting precedents when permits aren't obtained beforehand. And I just worry about setting a precedence that anyone can just say, well, I forgot to get a permit, and we're just okaying that, and others will see that as acknowledgement or that we're allowing that. So that's just a concern. I understand that the way the current process is, there doesn't seem to be a good way around that to avoid that going forward. So that's just my concern. But my answer is yes.
Richard Prokanic?
Yes.
Alan Rich?
I agree with Cheryl. Also, I think we really need to focus in on some of these contractors that are not doing business correctly. But my vote's yes.
Gary Rosenthal?
I'm going to say yes also, but with the understanding that our applicant here understands that he cannot add anything else to this property. He has to go through all the inspections, and I agree with Alan. That's why I asked at the beginning with this contractor, something should be, he should be held accountable here.
Robert Shepherd?
I'm going to vote yes. And I think that all of the comments made by the other board members are all the things that I was thinking at when I was looking at this. And I see this as a little differently than I was looking at it before I came to the meeting. I was very concerned that the applicants had simply just gone ahead and created this, but this is a very sort of a complicated situation, and I think that for these particular people, under these circumstances, what we're granting is appropriate, but it can't become a situation where you just come in and ask for forgiveness instead of getting permission.
Wasim Verdas?
Yeah, I also agree with all the other statements, and I'm going to vote yes, because it sounds like a lot of the deviations were before they even purchased the properties, so to me, relevant, so I'm going to vote yes.
And Robert Thomas?
I have to agree with really all the comments that have been made previously. I have to also say that, as Mr. Shepherd said, I might have come into this hearing thinking differently, having visited the property. Whatever the reason, the appearance doesn't do well for you coming to a hearing like this when you're looking for forgiveness, so to speak, for doing something without permits. Having heard the whole story, have a little bit better understanding of it, and I hope you have a little bit better luck with this than you had the first time. I do think, like Alan said, there ought to be some accountability to the people who do the work. That contractor has probably done jobs, as was mentioned, knows anyone that's doing that work regularly probably has a very good idea that they need some kind of paperwork or permission in order to do it.
Yeah, what I can do is, the reason I didn't have an answer for Alan's question is that that's not something that zoning really gets involved with. There very well may be a process in the construction department that I'm just frankly not aware of, where they can find contractors. I don't know, but I'll bring this up to the construction department tomorrow and find out.
Anyway, I'm saying yes. All that. I think that's the only thing I didn't say. Anyway, good luck with it, and that should be it.
Yep.
Anybody object to closing?
I move that we adjourn.
Second.
Meeting adjourned.
Thank you very much to all the board members. Thank you.
Thank you so much.